Good morning, everybody. Representative Long, if you would introduce yourself to the rest of the committee.
Hi, I'm Patrick Long, aka the other Pat Long, for those of you that are experienced at the State House, and represent Manchester Ward 7.
Right. And congratulations, everybody's here except Representative Pearson. Director Jurius? Yeah, this is our last formal orientation of the Office of Professional Licensure and Certification, which we deal with to a substantial degree.
Good morning. I'm just going to grab a pen so I can jot some notes down if you have questions that I need. So you save the best for last.
No, we had a nice supply of licensing bills we could stack up to make a full day.
That's good. All right. Thank you so much. So just for the record, my name is Deanna Juris. I'm the Executive Director of the Office of Professional Licensure. Very happy to be here this morning. I did hand out a presentation, fairly high level, really just 10 or 11 slides. I'm sure there'll be a lot of questions that'll be generated just as a result of the conversation here. So I'll just kind of start walking through it. Happy at the pleasure of the chair to take questions throughout or wait till the end, whatever your preference is.
I think questions during will be more focused.
Perfect. All right, sounds great. So I do have with me as well, this is Nicholas Fry, is my general counsel, does primary legislative work. So generally contact would be between the two of us for any questions that you have. I do also have here available for questions. Heather Kelly is my director of operations, deals with many things, but including budget, finance, fees, that type of thing. And then Bethany Cottrell is my director of licensing and board admin. So they're available if there's more technical questions as well. So I'll just go ahead. Yes.
That person you mentioned, the last person you mentioned is not on your sheet. Would you name her and spell her?
Absolutely. Bethany.
Bethany.
And then Cottrell. Cottrell. Yes, 2 T's and 2 L's.
And what's her title?
The director of the Division of Licensing and Board Administration.
Thank you.
Just for your own awareness, I do have a third director of enforcement. I'm happy to give you her name and title just for your benefit. She's not here today.
Might as well while you're doing it.
Yes, so director of enforcement is Sarah Rogers. Sarah with an H.
D and Rogers.
No D. Rogers.
Director of Enforcement.
Yes,
Thank you.
absolutely. So just go ahead and start. The mission of the New Hampshire OPLC is to safeguard public health, safety, welfare, environment, and the public trust of the citizens of the state of New Hampshire. I like to say, if the law says it, we do it. If it doesn't, we don't. So that is my preference. That's my mode of operation. At any point, if we're trying to untangle a situation, whether it's in rulemaking, procedure, operations, we're always going back to the law to see what does it say, what do we need to do, what are we mandated to do. So that's more my MO. It's not a very flashy mission statement, but that is largely how we're pursuing our current operations. So the office structure here, just to give you a little bit of a picture sense. So we have the director, the Division of Enforcement, again, Sarah Rogers. So that is investigations and prosecutions on that side of the house. So complaints come in, they're evaluated. Can be a recommendation for dismissal. We can talk more about that enforcement process on a future slide, but there's investigations and prosecutions, 2 separate pieces of that division. Licensing and board administration, again, under the direction of Bethany Cottrell. That has board administration. The office has 57 boards that it currently provides administrative support to. 7 of those are advisory, and 50 of them are what we would just describe as a full licensing board, just for the sake of the distinction. That division has board administrators. So we have a team that support, each of them support several boards, but are assigned to them, are at every board meeting, managing the agenda, coordinating with the chair, technology, different pieces, basically that service to the boards. Licensing, which is individual and customer service, are in that as well. So that is the folks answering our phones, and then issuing credentials, responding to emails. I have a few more details on a future slide about that as well. And the third piece over there is compliance. So that is inspections now in the PLC 400s. So cosmetology facilities are inspected, pharmacies, and then other pieces. So where there's a compliance component, it's not necessarily enforcement. It's just ensuring that they're complying with the statutory and the regulatory mandates. So those are all live in that division. That is our largest division. The third is operations. So that is Heather Kelly. That includes human resources, finance, information technology, contracts, project management, and anything else that I need. Currently, under the umbrella kind of the executive director's office is general counsel and board counsel. So those are, so that would be Attorney Fry. And then I also have an attorney, Elizabeth Baker, who provide agency counsel. And then there are 3 positions that are designated as board counsel. They're assigned specifically to boards. They are in every board meeting, advising the boards, providing them legal support during their meeting. And then the Hearings Bureau also reporting up to the executive director. We have 2 administrative law judges. This, before the reclassification from DOP would have been a hearings officer, basically a presiding officer for adjudicative and licensing proceedings. And then 1 hearings clerk that facilitates the administration of that. So I will pause there. It's a big umbrella overview, but if you have any other questions, I will get into more details. But
How many hearings officers?
2. And then 1 clerk, so just the 3 down there.
So what's the total number of staff in the OPLC now?
I'm going to look at Heather. As you understand, that it's fluctuating regularly, just with hirings and departures and changing over there. Do we have a head count? So authorized is 120. I think currently filled positions is closer to 104. Accurate? Yeah. The next slide, I will not bore you with reading every single board or profession that we
Thank you very much.
that we regulate, but just for your own situational awareness. And if you're wondering, does that live at OPLC or somewhere else, this will provide you an exhaustive list of what is here. I will just make a quick note, out of alphabetical order at the very end. I have doulas, lactation consultants, and community health worker. Those are new voluntary certifications that we're currently engaged in rulemaking on. We're engaged in that process right now.
Would you mind indicating the ones that are advisory?
Yes. Just going through the list. Assessing certification is advisory. I'm going in alphabetical. I'll start from the top.
Assessing certification.
Yes.
Yes, there's 7 of them.
There are 7. Yep. Body art practitioners. Court reporters. Yep. Electrology. Scrolling down, apologize. Massage therapists. Medical imaging and radiation technology.
What- yeah, Imaging and radio, okay.
Yep, about a third down the second column there.
I think we're up to 6.
Mm-hmm.
Medical technicians?
Medical technicians is not presently an advisory board. Recreational therapy.
That makes 7.
All right. Actually, medical technicians aren't exactly a board. They're just a profession, right?
There is currently there's not presently a board. That is correct.
Thank you.
Yes. And then around that same thing, ophthalmic dispensing professionals is also just a credential. There is no associated board with that profession. Okay. Moving on to the next. This is pulled directly from the statute, but I figured just for a broad picture, I would go over the executive director responsibilities per RSA 310-4. So responsible for supervision of division directors. Currently it has chief legal officer and chief of staff. Those positions the legislature was included in a bill last session. Those positions have not been posted or filled due to current budgetary constraints. So those are vacant, pending funding.
You said chief of staff and which?
Chief legal officer.
Thank you.
So again, employment of personnel needed to carry out functions of the office and the boards. Examination, processing, and approval of denial of an application for licensure, certification, or registration for all license types. So the nuance there is the boards, the licensing boards, they will determine the objective standards for the licensure. So the professionals that are assigned to these boards are developing the criteria, and the office is the one that's basically doing the processing and the evaluation. If there is a question about whether a licensee has met the qualifications, whether it's something very technical or related to the profession, then staff are sending those to the board for review for their expertise. So if there is a question, we're not guessing, we're consulting the board. Letter D is the investigation of all complaints of professional misconduct. So again, the office is responsible for that investigation. Those reports of investigation go to the board, and then adjudication or a dismissal, that action is taken by the board from there. Maintenance of the official record of the office and boards in accordance with the retention policy. So that's just all of the record holders are not held by the boards. It's held just by the office. So any compliance with 91A records requests are processed by the general counsel office, not by individual boards. Letter F, drafting and coordinating rulemaking for all boards within the office with advice and recommendations of the boards. So in that case, that is the same across every board, whether advisory or a licensing board, is that we're getting advice and recommendations. Now, if it's a full licensing board, they have their own chapter. So optometrist is one that I was reviewing yesterday. So that's optometry rules, and they have their set. If it's an advisory board, it would be part of the PLC. So the office chapter related to that profession, but again, in consultation with those advisory boards who are the technical experts in that regard. And then, yeah, so letter G, I already alluded to, maintaining confidentiality of information, documents, and files in accordance with 91A. The last one in that statute I left off because it just says I have to produce an annual report, and I didn't think that was particularly relevant for this discussion, but it is in there. Wanted to quickly, so those are the executive director, kind of the office responsibilities, and I wanted to go over the board responsibilities. I touched a little bit on board versus advisory board. So the rulemaking is the first piece here. Just to give you a general outline of how things are laid out, the 100s would be organizational rules, definitions, kind of just general grounds, table setting, if you will. The criteria for initial licensure would be established in the 300s. Criteria for renewal would be in the 400s, as well as continuing ed requirements. Ethical standards would be in the 500s generally. And then there's other regulations, scope of practice. Pharmacy goes up to 2600. They have pretty extensive rules. So anything after 500 is miscellaneous at the determination of the board and the office in the drafting there. But if you're looking for organizational rules, initial or renewal, you're looking at 1, 3, and 400s for any given profession, or the PLC rules, which would control the process for those things. So just to give you a little bit of a framework. The disciplinary process, again, for boards, they make the final determination on whether to investigate a complaint or dismiss it. That determination can happen at two points. So the office undergoes a facial review of a complaint. If they determine that it is not legally viable, there will be a dismissal memo drafted and sent to the board and say, we recommend that you dismiss this complaint. The board does not have to dismiss it. They could say, nah, you really got to look at this again, send it back up for investigation. So that's the facial review. We say dismiss it. The board says, go take a closer look. Comes back up to enforcement. That determination could also be made if the office says, we think there might be something here, produces a report of investigation. At the end of that, make a recommendation to move forward. They could say either dismiss or move forward. So then the board would make a decision there. So those are kind of two parallel tracks pending that facial review. Yes.
Thank you. I've had some concerns from licensees that at that point you should be reporting back to the complainant that the board accepts or rejects the complaint. Is
Yes.
that your common practice?
That is the common practice. I have been hearing of instances where that has not occurred. So we're tightening up that process and policies to ensure that is happening, because that is the goal, is to notify them when a matter is closed. They know it is over. Yes.
Yeah, or even, thank you for your complaint. We've decided it merits investigation and we'll be working on it. I mean, either way, the problem is when someone makes a complaint and it,
And radio silence.
vanishes.
Yes. I will add, we did institute a reply just when a complaint is, when it is filed, just confirming receipt of the complaint and saying, thank you for, for filing this. Here are the two, either it will go this route, that it'll have this review. It will either go to the board. So basically kind of laying out what I just laid out for you. Here are the next steps. You will hear from us in these instances. So I'm hoping that provides some clarity. That is a new within the last month, new kind of just communication out to complainants.
Thank you. That solves one concern.
I will keep going pending questions. So they make the final determination on whether to dismiss, issue a confidential letter of concern, or commence with a disciplinary proceeding. So similar piece there. They are the fact finders in disciplinary proceedings. So if we are in an adjudicative hearing, the board sits as the finders of fact. They work frequently with board counsel to produce those findings of fact for the presiding officer, to impose sanctions in disciplinary proceedings, approve or deny settlement agreements in disciplinary proceedings. They decide motions to dismiss that are based on fact and law with the presiding officer. They can emergently suspend a licensee's license with the presiding officer. And they can delegate any of their disciplinary proceeding responsibilities to the presiding officer. So one instance, there's an emergency process, which I'm happy to talk through. Probably I would have Attorney Fry talk through it. He has a really good understanding of that, because distill it for you. But one example would be 3:00 on a Friday afternoon, we receive a complaint that we would consider emergent, that action needs to be taken expeditiously. We don't want this person to be able to work to practice through the weekend because of whatever alleged violation. Those are quite minimal. It's not a regular occurrence, but they do happen. To convene a board in the last hour, or even, we could work late, but on a Friday afternoon would be quite challenging. So we do now have the opportunity where if something comes down to hearings and we need that, we can work with the board chair. We can try to get a quorum. If we cannot get a quorum available for that, they can delegate that decision to the presiding officer to be able to move forward in that case. So that's what is covered in that last bullet point.
Representative Seitek?
I've never heard the adverb emergently. Does that mean on an emergency basis or in case of an emergency? Is
Yes.
that what that? Wow, that's quite a word. Thank you. Emergent.
We always try to make EDNA educational.
I will. All right, I'll keep going. The next slide for licensing, as I mentioned already, the board is responsible for determining the criteria for licensure under statutory scheme as permitted by law. Consult with the executive director on criteria for licensure by endorsement or reciprocity under 310. So that is there's a lot of different words that are used somewhat interchangeably, but the licensure reciprocity, that's the portability if you're licensed in another state, that piece there. The word endorsement is used for clarity. I think I'm not an attorney, but I think when you say reciprocal, it implies it goes both ways. We obviously can't tell other states what they have to do. So it is, by definition, we cannot say it has to go both ways. We'll accept you and you accept us. That's more of a compact model, but again, that's a different mechanism. So licensing by endorsement is the implementation of HB 594 from 2023 that would say that portability between states. Making recommendations to the office on how to proceed with processing an application. So again, that was if there is a question, criminal background check comes back and we need some consultation there. There's pieces included in that. And then act as a fact finder in licensing hearings upon request of the office, recommendation of the board, request of the applicant, or upon board decision. So there's a lot of variables there. If you get too technical, I'll kick it over to Attorney Fry. But
Sci-Tech again?
Would you mind walking us through the process? My daughter graduates as a nurse, okay? She does her clinicals. Who examines her? Who says she's qualified? Do you send the papers? Who keeps track of her hours? How does that actually happen? Can you mind walking through Mary Zytek, nurse?
if you don't mind, I'd love to have Bethany Cottrell come up and answer that.
At some point, if that's appropriate now or when she's going to get to it.
I think that would be appropriate now.
Okay.
Okay.
I don't know.
Good morning, Bethany Cottrell, Division Director of Licensing and Board Administration. Nice to see you all. Every license type is a little bit different in their processes, but nursing, for example, if I graduate from my nursing program, say I go to St. A's, I finish my clinical hours, all of that has been documented through the school. And then once I graduate, I apply to OPLC to take my exam. What we call it is a ATT. They apply to take their test. As a new nursing grad, I then get approval from OPLC to sit for that exam, and we let the exam company know. Go ahead.
The board, OPLC administers the exam or the
We
board?
do not. Nope, we have a third party that administers the exam that we have contract with.
Okay.
Sorry. We're lucky that we're all very collaborative, so we're very thankful to be able to work together. During that time, the licensee has like a provisional license where they're able to work under certain restrictions.
Which you issue.
Correct. And then we get the results back from their exam. They have to have their FBI criminal background check done. And then once we get all of that together, then they get their full unrestricted license.
Which you deliver, you send the paper.
We email them, but yes, they receive that from us.
You get an email certificate?
Yes.
Wow.
It's not nearly as dramatic as it used to be.
Right. It saves a lot of money in postage, so we're much more fiscally responsible when you have thousands and thousands of licensees.
Representative Broder?
I do want to make a comment about that. So last year, one of the things that we did was we gave the office the authority to issue the licenses, and an online system was put together so that what was typically happening, and correct me if I'm wrong, was that somebody would send an application in by mail. It would be missing a document, so the office would have to mail it back to the person with all their packet, have this thing added, mailed back, and it was this going back and forth that was causing an issue. And so now the way the system it implements itself is that someone applies through the portal, and unless they've attached all those documents properly, they can't go to the next step. So there isn't this regurgitation of mail going back and forth. And I think this has, from what I understand and from speaking to the people who have requested licenses, the process flows better.
Yeah, and I will say excitedly that yesterday we run our numbers biweekly. And so yesterday I was looking at our biweekly reports for new applications, and statutorily we have 90 days to make a decision on our applications. That in the past, because of this back and forth that Representative Grota was talking about, often has gone beyond that. Yesterday, when I looked, 87% of our applications were a decision was made within the 90-day time frame, and 57% were within 14 days. So within 14 days, 57% of our applications were approved and out the door, which is huge, especially compared to other states.
Why shouldn't it be 10 minutes, not 90 days? Once the third party sends back, they passed the test and submitted their credentials.
So in the nursing situation, the initial application is that first part where they say, okay, I've graduated and can I take the test? And so then we have to approve them. They have to take approve them to test. They have to take the test. So there's pieces in there that do delay that. Engineers, for example, have up to 2 years to take their exam. So that could delay the initial application to when it actually gets approved. Some of those are the outliers. But we are within 2 weeks. Most of our applications are being approved and out the door.
Why does anyone need approval to take the test if that's not the?
Wait. Yes, Representative Long?
Why does anyone need approval to take a test if that's not the final step in their licensing process? Because you could always deny the license on some other basis if there's some other reason they're not eligible.
It's an interesting policy question. It changes, not even just board by board, profession by profession. So some have statutory requirements that they have to be approved to sit for the test. Some boards have made that decision in rule that they would have to approve members to take the test. We could get, I don't have off the top of my head the number of boards that have that requirement, but there are more than one that would say they control who can sit for the exam before even considering the application.
Representative Seifert?
You don't make that. You don't make the decision who can sit for the board. The boards do.
Right, the
Or
board
they-
set those rules or the statute, and then we approve or deny based on that, correct? Yep.
Yes, if you want to do some statutory cleanup on this issue, I'm sure it would be well received.
This goes back to my point. If the law says it, we do it. If it doesn't, we don't. If you change the law and says you cannot approve anyone can take the test, that's what we will do.
Okay.
Thanks, Bethany. So then just the last piece here, kind of our miscellaneous catch-all, is issuing declaratory rulings on its rules or on the statutory scheme. So sometimes a question comes up, somebody petitions the board and says, what do I do in this scenario? What would happen? The board can issue a declaratory ruling to give clarity on that piece of it. And then standing orders related to its statutory authority. So a board can issue a standing order to say, every single time this happens, I want X to happen. Please don't ask me and have an hour conversation every time it happens.
Yeah, saying a criminal record check that only has one WI doesn't need to be considered by the board, for example.
Yes. And we do, specific to criminal records checks, we have it established for several boards. We'd like to have it across all boards that require that criminal history check, that there is some standardization where it says, where the board agrees, here are the instances where we don't need to see it, just issue the credential. 100% of the time we're going to say, yes, you don't have to bring it to us, or here's the ones that we still need to see. So we're working on implementing that across all of them. We're partway there on that piece of it. I believe that came up, Representative McGuire, we were talking with the LADAC board specifically. There were some challenges there. So I think that has quieted down, and we'd like to do that across everything. Just touching on a few more licensing and customer service numbers. So in 2024, we had 212 plus, that number's always fluctuating, active licensees. Our population has grown, so my 20% of the state is not quite accurate because we're up over $1.4 million, people now in population, but a large percentage of the state has a credential from the office to work. And it's constantly on my mind. A conversation I'm having regularly with staff is that we need to continue to be efficient, effective, not do more than we need to do, and timely resolution of these concerns, because this is people's livelihood. It's their ability to work. And so that is top of mind for me at all times.
Representative Berta?
So if I take let's just take I take 2,500 people, which is in the middle of 2,000 and 3,000. And if I multiply, how long? I guess I'm saying that if we take, let's just say we take 50 weeks, okay? That's 50. I don't. Let me just do it off the top of my. I can't do it off the top of my head. So 50 times 2,500 is 125,000 people. So how can we have? And a license is 2 years, right? So does that? So we're saying that we're turning it over every 2 years, and that requires 2,000 to 3,000 people a week.
So that's a really rough estimate. Some weeks it's under 1,000. Some weeks it's 8,000 if it's renewals. So it is extremely variable. These expiration dates it's from the date of issuance. So this, just to give you a general sense of the amount of licenses that they're processing, somewhere 2,000 to 3,000. Sometimes it's a lot higher. Sometimes it's a lot lower. But this is just to give a general gauge of how many they're processing week in and week out.
Follow up. Because one of the things that we did change was that rather than every 2 years on an anniversary date, which was causing this big clog of licensing, was that it would be done on the date of issuance. So do you think
I'm
that?
sure that changeover is still in process.
That's what I'm wondering. I think that changeover is probably still in process.
And there are some, I will say, so nursing is a good example of this. All nurses graduate from school at the same time. They all sit for their test at the same time, right? Or at 2 or 3 times in the year. So you have very busy renewal periods just based on the school calendar. So it's not that they're required to be issued on a certain date by anything except for most of them are taking their exams in May. So there's there are still those large seasons there, just for the situational awareness on that.
One last thank you. So maybe perhaps what might be interesting to us is the number of licensees. We have 212 licensees. So maybe we pick, what will the 80-20 rule apply? Do 80% of our licensees fall under a certain number of specific boards? You don't have to answer that question now, but it would be interesting to know.
The annual report, I've only seen the 23 report.
Oh, I apologize. I do think I sent it to you. I will send it to the committee. Yeah.
Please, yes,
to.
we'd like
Yes.
to see. That has a report of how many licensees per board.
Yeah, so I know, so not for the purpose of this presentation, but I know exactly the number of licensees for every single board, and as Director Cottrell mentioned, I could send you a report of every 2 weeks the exact number of credentials we issue. I don't think you want that, but
No,
we do
thank
have
you.
those numbers.
But we
yes.
do want the annual
The licensees.
report.
Yep, happy to do that.
Representative Howard? Oh, Representative Schmidt.
Thank you, Madam Chair. So I appreciate the value of standardization. In many instances, what works for Board X can work equally well for Ward Y. But do we know that a standard license period is appropriate for all boards, all professions, and so forth? Are we looking at what other states do to see whether we are evolving as the board, as OPLC evolves? I mean, some of us were here before the OPLC was. I'm one of them, and it's gone through a lot of twists and turns. With executive directors who were relatively short-term and candidly not all that effective. So it sounds to me like OPLC has gotten kind of through the shakedown period of discovering that this doesn't work that well, and no, let's do it this way and give it a try or whatever. So I think we're at a point where we're into a more intermediate stage of development. But let's get into my individual questions. So are we looking at what other states do with regard to duration of licenses?
I have not personally looked into that. I will
Well,
say,
you've only been in the position for a relatively short period of time. You're in your shakedown period to some degree as well, getting to know what you're
Yes.
doing and
Excuse
how
me,
well it's working.
Representative Schmidt, the duration of the license in all cases is specified in statute. We're the ones who should be looking into what other states are doing, should we wish to make a change.
Well, I take the chair's correction for the value that it has. But the thing is, some of us are brand new. Some of us are quite old and have been in this position for a long time. So, to the degree that we don't have the kind of global experience that a board or an organization such as OPLC would have, because they attend conferences, they interact with all kinds of other states in many respects. So, I think it's what they learn from working with other boards in other states is something that they should refer to us for statutory changes. I totally get that, but that's the direction I'm going with my
I
question.
haven't noticed any hesitancy on the part of the boards to request statutory changes when they want them. So, I mean, I think 3 or 4 boards have come to me this year for statutory changes.
That's interesting. I'm glad to hear that. But the point is, we have a whole half of our committee is brand new to the legislative process as well as to this committee. So I'm exploring things which I think the new members can benefit from discussing or hearing raised by more experienced members of the committee and so forth, but also from the director. So if you don't mind, I'd like to
next
have an
question?
answer to my question.
I would just add, so again, if the law says it, we do it. If it doesn't, we don't. The 2-year license period is extremely helpful to us operationally because we're on a biennial budget. And so it makes revenue much easier to predict. We're much more accurate in those predictions because we know every 2 years, this is not exactly right. We don't know how many people will get a license, but it's much easier to predict within that 2-year window. So for the process of budgeting, revenue estimates, it is, again, if you said nope 3 years, we would make it work, but it operationally we really do actually like the 2 years. What other states are doing, their funding sources might obviously be significantly different than ours as well. So for the current process that we have now, where it's all agency funds, it's set by fee, it's very helpful to us. So I will just anecdotally say that we would certainly not request that you change that.
Thank you.
Anyone else? All right, thank you.
Okay. I'm really excited to just highlight our customer service team. So between licensing and customer service, we have about 35 staff members that their full-time job is answering the phone, answering email, issuing license credentials. They do an excellent job. We're answering between 95 and 99% of calls presented and 100% of daily emails. Monday was abnormally high, but on Monday, the office in the 7.5 hours the 8 hours were open, fielded 350 calls. It is in the thousands every week. It is quite extensive. So we have a large team that is doing that. And Director Cottrell highlighted this piece of the licenses. So more than 80% were issued within 30 days. And I put the dates in specifically because between 12/28 and 1/10 would be holidays, lots of people on vacation. We have a lot of renewals. So even over this holiday period, more than 80% of them were out within a month. So I'm really excited about that. Kind of going back to a little bit about what Representative Schmidt was talking about, the office has undergone a lot of changes. And with that, so with law changes comes rule changes, comes policy changes. And we're still building a lot of those processes out. The focus certainly was we need to get licenses out the door and we need to answer the phone. And so that side of the house, the licensing division, has gotten a lot of work, a lot of procedural pieces there. And you can see by the numbers we have the data from this time last year to now as a dramatic improvement. And I'm really happy to be able to share with you. that leads me to my next slide to say that the enforcement side of the house is next, and that's the plan for 2025, is to really iron out those processes to ensure that our data is good, that there's a timely review of complaints, that the investigations are thorough, but they're expeditious. And so to give you a little bit of a sense here, the division is currently auditing all pending complaints to verify the status. So there were a number of factors here. There were some data issues like physical in the system that need to be verified. There's fields that are incorrect. And so now we're looking into every single individual complaint to ensure that that data is accurate, and to verify this is indeed a complaint. All of this is accurate. The other piece that they're working on is the review for legal viability. So that the facial review I talked about at the beginning, where a complaint comes in and it's initially reviewed, was not completed for complaints that dated back, that were in the backlog when that law went into effect. And so what we're trying to do is go back and do that review as well to say, do we have some more that we can recommend dismissal for here, and then chip away at the backlog. So they're currently working. I have messages in my phone right now from the division director who says that we're even further expediting that process. The goal is to be done within the next 3 weeks to verify all of the complaints, to have that data be clean, and then to start working through that backlog. So you can see the numbers here. We have 271 verified, and so it's almost exactly 10% of the 2,771 unverified pending complaints. So that's a large number. I am undeterred. We need to make sure that the data is good. I don't want to send investigators out on something. I need to ensure that it is a verified complaint before we start doing that work. We're working to streamline processes, collaborate with boards. I think with all of the changes that happened with the office, one of the things I think is there sometimes was a perceived division between the work of the boards and the work of the office. And I just don't see it that way. In conversations I'm having with the board, I say, look, we all have the same legislature passing our laws, right? We have the same statute, and we have the same boss. We all work in the executive branch, especially even for myself and board members. We all have the same appointing authority. We all work for the same people. We're doing the same thing. And so I'm trying to, if there was a gap, close it. And even if it's perceived, close that perceived gap to say we're all moving in the same direction. We all want to ensure public health and safety. We want this to move as efficiently as possible, and we want to protect the public. And so that looks like this improved communication with them, collaborating, seeing, okay, we're sending you dismissal memos and you're just not agreeing, and you're sending everything back up. What do we need to change? And they're saying, we need more details. You can't just say, dismiss it, we know, right? Give us some more specifics. Tell it, just a few more words on a page. So a memo, instead of a half or 3/4 of a page, it's a little over a page. The board but they have enough information that they feel like they can make an educated decision, and that they're not afraid they're missing something. So that's one that we're instituting. We're collaborating in that way. Now, we can't always talk specifics of a case because they have to sit as fact finders in adjudication, but just to speak generally, what can we do? How can we work together to move this forward? And I'm excited about the progress. I do think we're moving in the right direction. I have a monthly call with all the board chairs. I'm hoping to increase that attendance. I don't, we have 57 boards. I might have 10 at any time. That would be a higher week. And so I'd like to facilitate more of that conversation. I do think the ones who attend find it profitable. And so just trying to make sure that we're open and we're moving forward in that way. I'm happy to talk a little bit more enforcement. My director is not here. And like I said, this is the one, right? I want to be able to come and give you the licensing slide, but for enforcement at this time next year. So.
Leah?
Thank you, Madam Chair. Thank you for being here. We spent some time together last year with a bill that dealt with the Board of Medicine and review, pretty much what you're speaking about right now. We walked away from that interim study bill saying that you guys were going to work together in order to find a process. I was curious if that's one of the ones that's moving along smoother, or because there were some big issues that led to that discussion, is that something that's still a work in progress?
I would say that all of our enforcement is a work in progress. But I think the collaboration between the board, so that the potential wedge that I was saying, that perceived wedge, I do think is removing. I'm in their board every month when they're there. We're in communication. I think we're getting ourselves on the same page to all move in the same direction. So there is not animosity. I do. So I think there's no quantifiable way for me to say that, except for that the relationship is much better, the collaboration is better, and we are all moving forward in a good direction. So I'm optimistic about specifically that board.
Thank you. That's helpful.
Yeah. Right. I wanted to touch a little bit on rulemaking. I know that this is the policy committee. It is not the Joint Committee on Legislative. I won't even name the acronym. You know what jail car is. OPLC was responsible for over 25% of the initial proposals in the rulemaking register in 2024. I like to highlight that because I'm very supportive of all my executive branch partners, but I have 1 full-time and 2 part-time people doing rules in this office, and we do 25% of the state's rulemaking. So I'm very proud of that. We do need some additional resources. There's a lot of rulemaking to do, but we are getting it done with the limited staff. So I have 3, not even 3 full-time people doing 25% of the state's rules, just because each board has its own practice act. There's a lot of rule changes that are happening regularly. So I like to highlight the work that they're doing. And if any of you are on jail car, get ready. You'll be hanging out with us a lot.
You expect 25% in 2025 also?
Probably. Yeah.
Thank
Because C bullet point 2, we're still working with boards to update rules in light of HB 655 and then 1095, that statutory cleanup. Yes. So I think there's still going to be quite a bit of rulemaking. I wanted to just touch on, so RSA 31016 includes a new mandate for rulemaking specific to military service members. So right now we're working with individual boards. We have contacts at the Department of Military Affairs and Veterans Services. And so we're working on that. That is going to involve a lot more rulemaking. It's a pretty comprehensive project. I have 1 staff member who is the lead on that, who is coordinating, organizing, scheduling time with boards specifically to discuss this outside of any other rulemaking that they're doing or other business. There is some winning of hearts and minds because it is a little bit of a shift. It's not traditional education, but we're very committed to it and excited to see progress on that in this year. So you will see, I think, across several boards, you will see rulemaking specific to that piece of it.
Yeah. Questions? Thank you.
The last piece here is, I'll just touch really lightly on budget and fees. Again, I know this is a policy committee, and that is why I have Director Kelly here. If you have specific in the weeds questions, you don't want me to answer them, therapist by training. So we're now responsible for fee setting for all associated professions. So we have a fee package that we're working on. The proposal is going to accompany our next biennial budget. We are awaiting direction on what that budget will be, and then the fees will be set accordingly to the cost there.
And will this be in the governor's budget?
Our budget will be in the governor's budget. The fees are just set in rule. It's the PLC 1002s, and that will be a jail car proposal. But we're not putting the cart before the horse to say, hey, give us our fee revenue before they've set our budgets.
Well, you know, the idea is that the budget is set according to the fees. At least that's what the state does, so.
Yes. So
Our-
we also, yes,
All right, thank you.
they will be in tandem. That is certainly true. Yep.
All right, any general questions? Specific questions? Anyone? Representative Groda.
So I'm concerned about the enforcement, frankly, because that is the piece that I think is difficult to tackle. And so I'm just wondering if, you said that you would have a better idea in a year.
I'm sorry, not a better idea. What my hope is to have the success metrics that I'm able to present to you for licensing and customer service, these are good percentages. The time, like, we're efficient, we're getting things out on time. What I'm saying is that took some time, right? It was a year of ironing out processes, making progress forward. So my hope is within a year to have that success story. We're always improving, but that success story. So not that in a year I'm going to know what's happening, but in a year I can say, here's the number of cases that we got through. Here's the work that we're doing. Here's the time in which we're processing cases, and that it's going to be a much better story than I have presently.
So how will we know that happened in a year?
I'm assuming I will be talking to you again at some point, or happy to have a special meeting. I mean, I'll probably see you every week for the next 6 months.
Right.
Yes.
Okay, that's great. So in a year, we'll
And
take the-
it would be reflected in my annual report, which I will send to you now. And my 2025 annual report hopefully would have that as well.
Representative Schmidt?
Thank you, Madam Chair. So we have a new governor. One of the issues that we have heard on this committee in the past was that I have heard in any case from people who have experienced it, that some boards have members who are well beyond their sell-by date, so to speak, and they're beyond their statutory limit in terms of how long they've been on the board. And I've heard complaints about people who need to be replaced and were not replaced by the previous governor. So that's why I note the fact that we have a new governor, but she's going to need to know from you about complaints or a situation where people are on the board for too long. And where their term has been exceeded and they're still there because they haven't been replaced when they should be. So is that something that you're specifically aware of and looking into and so forth?
I think this committee will recall I'm personally very vested in that, as it was my responsibility in the previous governor's office for several years to be looking at those vacancies across the entire state. So we're very aware of that. I don't know what what Governor Ayotte's preference is going to be for receiving that information, but we have all in one place the roster of all board members. We know at any time any vacancies, any members who are in holdover. We're regularly communicating with board members as well to see if they are eligible for reappointment and interested, that they're personally keeping themselves in the mix, shall we say. So we are keeping tabs on that, and at any point can and do communicate that there are these vacancies. And again, as a person who looked at boards and commissions full time for a long time, keenly aware of that. I think it is a tale that is not unique to any state. Many governors get doing lots of things, and boards and commissions are not the most exciting piece of any executive branch. So, but I will keep it at the forefront because it impact. We have about 350 volunteers that come through every month in this office. So there's no other agency that's looking at that, right? The board members, there's a lot of board members. So we're definitely aware of that and like to keep that up to date.
As you know, our process says it goes through G&C, and it is a real drudge to try to keep on top of that situation because there are so many people involved, and so finding people. But I served on another committee 20 years ago before coming to this committee, and we had a situation where the committee chair went to the then governor, not Governor Sununu, a long time ago, and said, we don't want such and such a commissioner to be reappointed. Our committee, the previous committee, it was not satisfied with that commissioner, and our chair went to the governor and said, do not reappoint this person. So that's a pretty drastic step for a committee to take, but we do hear things because we're the eyes and ears of our citizens, but also of the executive branch in many respects. And so we will want to know that you are receptive to input from our side as well.
Always happy to hear from any of you.
Thank you.
Last,
And there are four of us on the
Excuse me.
committee. You indicated if
Representative
any of us
Schmidt,
are, there are four of us on the jail car. The three ladies
we
to my
talk
left
with them
and
regularly.
myself.
The last session, we had a notice in the House calendar saying we're looking for public members of most of the boards. Did that provide enough success that we should repeat it?
I didn't hear of any who applied because they saw it. It doesn't mean that they didn't, but that was not stated as a reason that they were interested. So I don't,
We'll wait a while then.
I can't say not to, but I don't know how much it yielded. Yeah.
I think we'll wait a while and then it'll be new again when we
Yes.
put it in.
I do appreciate your support in that. Yeah.
All right. Does anyone else have questions? Comments? Excellent job then.
Thank you. Thank
Haven't
you.
got the comments. For the committee, we will be resuming at 1 p.m. We have 4 public hearings on licensing bills. So take a break, go for a walk, whatever. If you're interested in the budget, the LBA is presenting to finance today. All right, for the committee's reference, I wasn't up on the current rules and did not announce that we would have executive session after today, so we will not exec any of these bills. If we agree on any of them that need it, we'll do those next week on licensing day. And it being 1 o'clock, I'm opening the hearing on House Bill 271, and I call the sponsor, Representative Schmidt.
Thank you very much, Madam Chair. No attempted emolument here. But I'm pleased to be before this committee today.
Peter, I can't see a beautiful face.
I don't know who he's trying to fool, but it's a nice compliment. So I'm pleased to be before you on behalf of House Bill 271 FN. And if you open the bill, you'll be urged to don't blink your eyes or you'll miss it because it's a very simple bill. But it's an attempt to address a real situation, and it's a serious bill. Most of us, I'm sure, are very well aware of the fact that we have all kinds of labor shortages across the country, not just in New Hampshire, but we are not being spared from the scourge of shortage in a number of important professions and occupations, and social workers are among those in greatest need. And this is a bill to attempt to address that matter. And we have several people to testify and answer any questions you may have, so I'll take no questions. But please pay attention to the witnesses that we've arranged for today and give them your thorough attention. Thank you.
Thank you. Lynn Stanley?
Thank you, Madam Chair, and members of the committee for hearing my testimony today. Thank you, Representative Schmidt, for bringing this bill forward. And please, for the record, my name is Lynn Currier Stanley. I am a social worker, and I am the Executive Director of the National Association of Social Workers New Hampshire chapter. Pleased to be here in support of this bill. I'd like to give a little bit of history and context just so you know where this licensure tier came from, and also in the mix of alphabet soup, what this is and what this is not. So about 4 years ago, Senator Bradley and New Futures were looking at the challenge that we were and are facing around people who are in emergency departments awaiting psychiatric hospitalization, looking at what some of the barriers to services were. What they found, one of the things that they found, was that the adults who were awaiting psychiatric hospitalization, the majority of them are on Medicaid. When looking at the children who are awaiting psychiatric hospitalization, the majority of them are on their parents' private insurance. And this is important because our community mental health centers have a Medicaid waiver, which means that the services provided by anyone, regardless of licensure, whether they have their master's or their doctorate, every service gets covered by Medicaid. However, for private insurance, which the majority of these children are on, private insurance requires that for a service to be reimbursed, that the person who is providing the service hold a license. So the solution 3.5 years ago was to create 2 additional licensure tiers. One of them was the licensed social worker. That's a bachelor, somebody who has graduated from an accredited bachelor's in social work program. We are not talking about that license. The other license was the licensed social work associate, LSWA. This is somebody who has their associate's degree or their bachelor's degree in something other than social work. Might be human services, might be psychology, could be a number of things. In having these two additional licensure tiers, that would allow for agencies to bill for these services provided by people who do not have a master's or a doctoral degree. What we are looking to have, one of the requirements for the licensed social work associate in statute right now is that they sit for the bachelor's social work exam that is put forward by ASWB, which is the Association of Social Work Boards. We are looking to have that removed, as we believe it is a barrier to people being able to actually access this licensure tier. The reasons why we are asking for the exam requirement to be removed is that we believe it's not necessary. These people, a lot of them are case managers, family support specialists, are already providing these services without a license. It is also expensive, and we don't want for one more, we don't need for one more financial barrier to stand in the way of somebody getting their LSWA, their licensed social work associates. Not only to take the exam, test preparation, if they don't pass the exam, retaking the exam. I will say this bill does not remove the exam requirement for any other licensure tier. It is just for the licensed social work associate. Thank you for hearing my testimony, and I'm very happy to answer any questions that you might have.
Thank you. I do have a question.
Sure.
These people have been doing the work without a license?
In community mental health centers and other agencies, because there wasn't a license. There was not a license available.
Isn't it against the law to do mental health practice without a license?
It is against the law to do psychotherapy. The licensed social work associate has a narrower scope of practice. There are things that they cannot do that the licensed independent clinical social worker or other master's level or doctoral level can do. These include psychotherapy, differential diagnosis, and signing off on treatment plans. Those things can only be done by somebody who has their licensed independent clinical social work, marriage and family therapy license.
Okay, thank you.
So we're talking about case managers, family support specialists, people who support the work oftentimes in people's homes or in the community.
Thank you. Representative Broda and then Representative Sellers.
Thank you. So I just want to make sure that I understand. Up until 3.5 years ago, when this requirement was put in place, it was a way for people who were LSWAs to be licensed so that the agency could bill for their work.
Correct.
Right. So what you're saying is that you want them to continue to have this license and no test.
Correct.
So what's the point of the license then?
The point of the license is so that the agency can bill third-party insurance. It is also a step on the professional development ladder.
Follow up. But there's no requirement. I mean, you're saying that they can get a license, but the requirement is that they have a bachelor's in something.
Oh, no. I apologize. There are other requirements that they have. They need to have a supervision agreement in place. They need 2 years of supervision before they can get their license. If they have their bachelor's, 3 years of supervision. If they have their associates, and yes, there are other requirements beyond the exam. We're
Okay.
just looking to have the exam removed as one of the requirements because we think it's a real barrier.
Follow up. So this test, this is it a national test?
Yes. It is ASWB, the Association of Social Work Boards, has the test for bachelor's, general, and clinical, and master's social workers.
Thank you.
Representative Sellers and then DeVries.
Thank you, Madam Chair. My question is, these workers at this point without the requirement for the license, do you see them working at our school systems and our school districts as part of the SEL program that they have in places now? Social emotional learning with the,
Thank you for the question. I have not heard of anybody looking to get their social work associate license to do that work because it would be about billing private insurance, and usually schools do not bill private insurance as far as I know. I guess I'm unsure whether or not somebody would
Okay.
do that. I'd have to think more about whether or not that is a possibility for them.
Okay, Representative DeVries.
Thank you, Madam Chair. This may not be a fair question, so please feel free to say so. But is the impediment the cost of the test, or is the impediment the passage rate of the test?
It's both. The cost it's $230 to sit for the exam. If you do not pass it, it's another $230, and people spend hundreds on test preparation materials, books, flashcards, classes. The pass rate for the bachelor's level exam is 70% first time. And that is for people who have their bachelor's in social work. That's not people who don't have their degree in social work.
Madam Chair, would you
Yes,
permit me
I'll
another? How about what would be the passage rate the first time around for people who do not have their bachelor's in social work? Do you happen to know that? Because those are the people who we're talking about here, right? So
Right.
if the passage rate, say for example, were 30%, I'm making up a number.
Yeah.
Confidence higher.
I do not know what the pass rate for people who do not have their bachelor's in social work would be. My assumption is it would be considerably lower.
Thank you so much.
Yes, thank you.
Representative Leon.
Thank you, Madam Chair, and thank you for taking the question. So is the role of this position basically clerical and setting them up with services when somebody else is making the care decisions? Or are they actually using some of those skills that are on this test?
Thank you for that question. It is possible that I will say it is likely that there are things on the exam that would be pieces of knowledge that the person who's doing this work should have, and skills that they are using. But I think that is covered in the supervision, and also one of the other requirements is a 30-hour prescribed training that covers all the social work competencies in between the time that they have their supervision agreement on file with OPLC and getting fully licensed. So not only are they going through this 30-hour training over the course of 2 or 3 years, but they're also getting the on-site training and supervision at the community mental health center or other organization that they're working for.
Follow-up?
And thank you. And with that supervised training, is that just a receptive training, or do they need to test and show their competency in it as a part of that training program?
They do not need, there is no test with that 30-hour training. I think the showing and meeting competencies is happening within their workplace where they are already doing the work, and discussed with supervisors and colleagues.
Okay, more follow-up?
Yeah.
Thank you. And this is my last follow-up. You said that normally it would be more of the administrative clerical, but they would sometimes
Yeah.
that from time to time they would need those skills. How confident are you that in that training, when they're supervised and in the training course, they'll have enough exposure to those more critical parts that are covered in the test? Because you know that, the number of hours you spend in a chair doesn't always correlate, or following behind somebody doesn't always correlate to the depth of what you've learned.
Thank you for the question. And I think I'm not sure that a standardized test is always the best measure of what somebody's competency and ability is. What it might mean is that you're good at taking standardized tests. I trust in the supervision process and the experience that these case managers and family support workers and other non-masters and doctoral level workers are bringing. And I also want to emphasize that I am a strong believer in consumer protections. I fiercely want to protect anybody who any client, any patient who comes in contact with social workers. It's a top priority. If I thought that there was any chance that this put the public in danger, I would not be sitting here. We would not have asked for this bill to be brought forward.
Thank you. Other questions? President DeLong?
So if I understood you right, Medicaid was able to pay to get this work done, even without a licensure process. So what do they do, or what do other states that don't have this do to ensure quality standards are met in this same type of work?
Thank you for the question. The reason why Medicaid will cover these services for the community mental health centers is because the community mental health centers have a Medicaid waiver. Other organizations and agencies do not have a Medicaid waiver. They're either absorbing the cost or the cost is being passed along to the client or the client's patients. When you look at other states that do have similar licensure tiers for people who have their associates or their bachelors, I think we have a more rigorous process in that requirement of the 30 hours of prescribed training. But those other states like Massachusetts, like Maine, are able to bill they are able to bill private insurance and Medicaid for those services. Does that answer your question?
Follow-up?
Sort of, but I guess I would assume that when Medicaid issues a waiver, there's still some process they go through or some demand they make to ensure that a quality service is still being provided. So what were their standards, or what are their standards for providing the waiver for equivalent work to be done?
That's beyond my knowledge. I know that the the people who providing this direct service are supervised. Things are signed. Somebody else has to take a look at what's going on and sign off on it.
Okay. Representative Sellers?
Thank you, Madam Chair. Just to make sure I heard that clear. So this person would always be working under a licensed person?
Correct.
Okay.
Okay.
Yet they cannot work independently.
Okay. Representative Pearson?
Thank you, Madam Chair. Early on, you mentioned something that occurred in the Senate in a duration. How long has this proctored exam been required in New Hampshire?
Thank you for the question.
You don't have to give me like exact date. Is this something that's been less than 5 years, more than 5 years, 25 years? What are we looking at here?
I took the I took the exam back in 2006. So, and for longer than that. So
Follow-
for the
was it- okay.
masters and the clinical level, the ASWB exam has been around for
Decades.
decades.
And this is the exam you want to do away with.
The exam I want to do away with is the bachelor's level exam for the licensed social work associate. That's the only licensure
Okay,
tier
that's
that
what
we're
I'm talking
looking
about.
at.
How long has that exist? How long has that been a requirement in New Hampshire to
Since the bill came forward 3.5 years ago and the LSWA was created.
That's what I'm looking for. 3 years this has existed. Okay.
But the test itself has been in existence longer.
For decades,
It's just that we
yes.
are expanding the number of people we're requiring to take it.
Correct. And I will say, even though the bill passed 3.5 years ago, people have only been able to get their their licensed social work associate for 6 months. There was a whole rule making process. To date, we have one LSWA in New Hampshire.
That appears to be a very small number.
Yep, it is.
Okay. Thank you. That's interesting. Any other questions? Representative Reeves?
Thank you. If this were to pass, how does this speed up or enhance access to what is the impact? How does it enhance access to mental health care for children who are awaiting care? Does it speed it up by a day, a week? What is the outcome?
Thank you for the question. I don't believe it speeds up the process for people being able to get services one bit. What it does potentially speed up is the ability for the agencies and organizations to get reimbursed for their services. We are not changing the number of people who are doing the work. We're changing the amount of work that can get reimbursed. Yes.
Thank you. Others? Representative Broda?
Thank you. So we put this in so that people could get reimbursed, but it was at that time, the reimbursement was tied into taking the exam.
At the time, the ability to get the license was, it is in statute that they sit for the exam.
Right. So they can have the licensure if they sit for the exam, and that was the bill that was introduced 3.5 years ago.
Yes.
And I believe the rules were just finalized. Is that correct?
Correct.
Okay. Thank you.
Thank you. Other questions? Thank you very much for your testimony.
Thank you.
Andrew Hosmer?
Thank you very much, Madam Chair. My name is Andrew Hosmer. I'm a senior policy advisor at Preddy Strategies. My client today is the Association of Social Work Boards, who you've heard mentioned earlier today. I will only take a couple minutes of your time, but I do want to hit on some highlights here. I appreciate the opportunity to testify in front of ED&A, but I will let you know the Association of Social Work Boards is strongly opposed to House Bill 271 FN. The ASWB licensing exams play a critical and crucial role in advancing safe, competent, and ethical practices to strengthen the public protection and to solidify social work as a profession. This legislation, which seeks to eliminate the licensing examination requirement for licensed social worker associates, threatens to undermine both public safety, professional accountability, and the overall integrity of the social work profession. A couple of something to clarify who ASWB is. ASWB is a nonprofit regulatory organization formed over 40 years ago to assist states in fulfilling their public protection mandates. ASWB is the nonprofit organization composed of social work regulatory boards and colleges for all 50 states, the District of Columbia, and some other countries besides the United States. ASWB is the only nonprofit organization dedicated to social work regulation. Their mission is to provide support and services to the social work regulatory community to advance safe, competent, and ethical practices to strengthen public protection. This bill pertains to RSA 330 capital A colon 18 small c, which became law in 2021. And as we have learned this afternoon, rulemaking was promulgated and completed just 6 months ago. Certainly, this was a bold step on behalf of the legislature and the governor to respond to what was going on in the behavioral health, the behavioral health and the mental health realms after 2020 and 2021. It was to increase capacity to address the concerns that many people really needed this care, and there didn't seem to be enough workforce to respond to it. In 2024 as well, the Interstate Social Work Licensure Compact became law with a promise it would help build capacity as well. If I'm not mistaken, it came out of this committee last year and was signed into law in July of 2024. On behalf of the ASWB, we really believe it's too early to determine the impact of RSA 330A 18C and the compact, and making a significant change to licensure at this point is really premature. I will share with you there is broad support for licensing exams within the social work profession. A groundbreaking survey conducted by the Association of Social Work Boards reveals an overwhelming endorsement for preserving social work licensing exams. Some of the numbers: 78% agree that new social workers should pass the exam for licensure, 78%. 73% believe removing the exam would be a mistake. 76% see the exam as essential to upholding the professional standards of social work. We certainly believe that licensure is a public safety imperative. Licensure is a cornerstone of public protection in social work, ensuring that practitioners meet rigorous standards of education, training, and competence. We also believe that licensure enhances professional integrity. It upholds professionalism. It facilitates interstate mobility, so more people can be served, and it certainly does support reimbursement. One of the most important things to ASWB certainly is considering the unintended consequences this bill may have. Though it may seem like a simple fix to a problem, a barrier to this designation, we think the unintended consequences, though, are really grave. We really don't know exactly what they are. It's a significant change in policy to facilitate a reimbursement correction. And we think that's a little too bold at this time, particularly given that the new law 330 really hasn't been in force for very long at all. Consequences of HB 271 would extend to clients who rely on licensed social workers for essential services. I would ask you to remember, and I'm sure that you already know, and I know this is shared by a social workers association, these are some of the most fragile people, at-risk people that our social workers are dealing with right now. We certainly believe that this exam really has to do with the practice. It's not necessarily clerical and I appreciate the question, Representative Leon. This is really will impact the clinical skills exhibited by our social workers. So I'm happy to take any questions and wrap up my testimony right now. Thank you very much for your time.
Thank you. Are there questions? Representative Long.
So if this is work that is getting done in other contexts, such as a Medicaid waiver or potentially just not getting reimbursed, even when there is no licensing, what public safety problems is it creating there? And how does changing the exam requirement for licensing prevent those problems?
Thank you for your question, Representative. I don't know if it's necessarily I can speak to the problems it's creating right now. What I will say is a standardized exam testing the competency of people who are dealing with our most vulnerable friends and family members and constituents is certainly levels the playing field. I would liken it to, in some respects, whether you're practicing law, you're a certified public accountant, or you're a commercial airline pilot. The academic portion of all of that is critically important, but ultimately, those who pass the test then possess the license to do this really high-risk work. And I would suggest social workers, it's a high-risk work as well. And we think that this is really a standardization of the licensing and plays a critical role in vetting. As we see, it's not an easy exam, 70% pass rate. I'd say that's consistent with the bar exam in many states as well. And it's certainly those that I'm familiar with who've not passed those licensure examinations go back. They have to dig in a little more. And when they do pass, I do believe they emerge as better professionals in their chosen field.
Thank you.
Did I answer all your questions there, Representative, or did I miss something?
Well, I think you answered it the best that you're able to, given the
I think so.
information
Thank
available.
you. Appreciate that.
Representative Leon.
Thank you, Madam Chair. Thank you for being here and thank you for that information about the role. My question is, since you seem to have a more of a national perspective as well, how many other states have this category of the licensed social worker associate? And I'm just curious about the utility overall. I understand why people would want it, but I'm trying to understand how it fits into the whole framework.
Thank you for the question, Representative Leon. I do not have that information right now. But certainly when this law was initially passed, the idea was to build capacity and to create another category. And I think we see this across the country, that we are trying to build capacity in all 50 states to make sure that those in need of care receive the care. But in growing those numbers, we strongly believe that anything that lowers the standard of entry may compromise the ultimate benefit we hope that patients and fragile individuals receive.
Thank you. Other questions?
Before I leave, too, Madam Chair, I have a letter from the Chief Executive Officer of the Association of Social Work Boards I'd like to leave with you. And I also have a letter that I'd like to leave with you from Sheila Rayno Finnegan, who is a licensed clinical social worker from Pembroke. And they're both in opposition to the bill as well. Do you care which side I
you.
hand it out to?
Representative Pearson is the closest one.
Okay, thank you.
I'm the mailman, but I also have a question.
Yes, Representative Pearson.
Thank you, Madam Chair. I'll have to lead with this. Are you familiar with the interstate compact that's been referenced?
I am vaguely familiar with it, yes. So I've got limited knowledge of it.
My question may be for you as well, because my concern is that a lot of the compacts that we enter into have standards, have minimum standards, have basic requirements, because you are entering into a compact where you can function across state lines. My concern is the relevancy of this exam to the interstate compact, and if there is an effect with the compact if we remove this.
My understanding is that this is to find that out.
Okay,
Mr.
thank
Greenland,
you.
do you think you can check that for us? Thank you.
Thank you, Madam Chair. Thank you for the question. I'm happy
Yeah.
to defer.
We do need to know that before deciding. All right. Any other questions? Thank you very much.
Thank you, Madam Chair. Thank you, members.
All right. Jake Berry?
Good afternoon, Madam Chair, honorable members of the committee. My name is Jake Berry. I work for New Futures. As Ms. Stanley indicated earlier, we worked very closely with you, the legislature, and with the NASW back in 2021 when licensure was originally established. I don't want to repeat too much of what has been said this afternoon. I do want to emphasize our strong support for this bill, and I do want to sort of reinforce a few points that have been made. When the legislature initially established licensure, it was not done so to enhance quality services or patient protections. As Ms. Stanley indicated, it was done to bring more financial resources and greater financial stability to our mental health system. Certainly to this day, we have LSWAs who continue to practice at community mental health centers without passing the exam. Or without being licensed, and they do their jobs very well. Certainly, again, as Ms. Stanley said, we are an organization that strongly believes in service quality. We would not support anything that we believe that we're going to lessen the quality of mental health treatments available to patients. But we do think this is an important step to undo what we think is becoming an unnecessary barrier to licensure, and therefore an unnecessary barrier for the influx of insurance reimbursement dollars into a system that desperately needs this money to be able to hire more professionals and provide more services to those in need. I think that is it. I'm happy to take questions, though I'm sure others in the room can answer them better than I can.
Actually, you might know more about this.
Sure.
Is this a step on the progress to licensure as a independent mental health counselor? Or is this a low-level position that the people in that position would stay in that position?
It certainly depends on the professional. These are important services that are provided, primarily case management services, helping individuals to access the treatment they need. As far as, but many of the professionals in this may seek further licensure to become, treatment providers themselves. We do hope that this does help to create and sort of reinforce the career ladder, that it does ultimately lead to further, professionals up the chain as well. But these are critical services that are being provided at this level as well.
Do I understand you correctly that it is not part of the normal progression of licensure?
The law was just passed in 2021. We just got through rules through last year, so it's hard to tell. But I think, yeah.
Okay. Other questions, Representative Leon?
Thank you, Madam Chair. Thank you very much, Mr. Berry, for being here. You probably know I'm new to this committee.
Sure.
Could you tell me which committee in the House this bill came to and how it was received with this language?
Oh my.
If you don't know, that's all right. We can look into it, but it would just be good to know sort of what the feel of the committee was when it came through the House.
I can tell you, I think in the end it passed with strong bipartisan support, but as far as which committee, I don't recall which committee it went through. I apologize.
Thank you. We'll have to find out. Representative Grota.
Thank you. So here's a little bit. So I looked up 330A:18C.
Sure.
And it's it's entitled the Licensed Social Work Associate Initial License.
Yes.
And it has some requirements, and typically when one has been has worked under a supervision capacity, after that supervisory period is over, then the person that has the license there's an understanding that the person would graduate from that position to the next step.
Certainly that's an option that's open for sure, yes.
That's what's typically, when I think about licensing, I don't think that everyone's going to stay in the guppy pool forever and swim around there. They're going to eventually, but what you're asking is for us to eliminate that test and allow all the people who wish to stay at that initial licensing to stay there.
Yes, that's right. That's right. And certainly, you know, again, understanding that there is a level of supervision, that they are coming in, having been educated and trained, you know, I think that, as you said, this is initial licensing, you know, and we just, it's important to bring people into the field in this way. It's important to support the work, and we don't want to see unnecessary barriers that again, don't exist within the community mental health system, by the way.
Thank you. Other questions? Representative Saitek.
Mr. Berry, so if someone, God forbid, wants to advance, they would eventually have to pass exams.
Yes,
written.
certainly.
Okay, so that does not go away.
No, absolutely not.
Okay, other questions? Thank you very much, Mr. Berry.
Thank you.
This bill will be going to subcommittee. Much more than it looked like at the first pass. House Bill 267, Representative Kelly. No. It hasn't, the new one hasn't arrived, and I keep forgetting to bring one of the old ones.
Good morning, Madam Chair and members of the committee. I am Diane Kelly, representing Hillsborough District 32, and I am here today to introduce HB 267, which regards chiropractic for animals. Those of you here last term may remember the previous iteration of this bill, which was expertly shepherded through a subcommittee by former Representative Tony Lakis and a whole bunch of really dedicated members who were able to work with the various stakeholders, such as the two New Hampshire Chiropractic Associations, the New Hampshire Veterinary Board, and OPLC, to craft language that allowed licensed chiropractors and veterinarians who attended a nationally recognized animal chiropractic program, which was to be determined by the executive director of OPLC, to adjust animals without requiring veterinary referral, and for chiropractors working without direct supervision of a veterinarian. For those of you who were not here last year, I'll give a brief background of why this is important. In the United States, chiropractors are considered primary care doctors, which means you don't need a referral to see one. So you can take your child to a chiropractor without a doctor referral. But currently with animals, it's kind of a gray area, and one that is currently being addressed by a lot of states, and will eventually have to be addressed by all states. Because people are becoming more and more aware of the benefits of chiropractic for animals. At this point, getting veterinary referral can take weeks because there's somewhat of a shortage of veterinarians, and it can also be prohibitively expensive. So in my own interest in animal chiropractic came about as a result of someone plowing into my truck at a gas station. I had my little dog with me. He was in a body harness buckled into a dog car seat, but he was seriously injured and he was miserable and probably wouldn't have survived without benefit of an amazing chiropractor who in one visit fixed the problem, relieved his pain. He did this big old doggy shake and wagged his tail and off he went. He was fine. Last year, we also heard testimony from a woman whose dog wasn't doing well, and she and her husband were not in a financial position to take her for veterinary care, but they heard about animal chiropractic, and also within just one visit, the dog was back to her happy self. So anyway, the bill last year sailed through the House and the Senate, and at the last minute, there was concern about the lack of explicit language regarding who was eligible. The original bill language said that anyone attending a nationally recognized animal chiropractic program would be exempt from veterinary licensing, but since only chiropractors and veterinarians can get in those programs, no one really expressed concern at that time. But at the last minute, it was felt that the language should be more explicit and more explicitly express that only doctors of chiropractic and doctors of veterinary medicine who attend a nationally recognized chiropractic program would be exempt from veterinary licensing. So with this new, more explicit language, it's my hope that New Hampshire can move forward with this matter settled so that caring animal owners can access this amazing care quickly and affordably.
Thank you. Are there any questions from the committee? Representative Schmidt.
Thank you, Madam Chair. Representative, good to see you again. So is this bill is essentially, or is it is it identical, or is it only essentially similar to the legislation you brought to us in the last year that did pass the House, as I recall? And did it die in the Senate? What happened?
It was vetoed by the governor.
Vetoed by the governor.
There is a report from our researcher on the history of animal chiropractor bills, which we have provided to you.
Thank you. So is it the same bill?
It's essentially the same. The only thing that changed is that the former bill said anyone attending a nationally recognized program, and it now says any veterinarian or chiropractor, licensed chiropractor who attends these nationally recognized programs.
Follow up?
Yes.
So as I recall, there were a number of people that came before us the last time with similar stories of difficulties in getting an appointment with a chiropractor to have a referral to. I had it reversed. Getting a referral from a veterinarian to be able to go to a chiropractor, and to the degree you've got an animal in pain, discomfort, dysfunction, and you're waiting for weeks, whatever,
Right.
with an animal that can't tell you. So it's back a little bit farther.
Right. And I'm really hurting and I really need help. Yeah. So that's the only change. And I spoke with one of the directors of the Chiropractic Association last night who said that both he and the other association were fully on board with it now. So I think
We're going to hear from them.
I don't see them here, but I'm happy to get written testimony from them or something if you'd like. Anyway, as far as I know, everyone is on board with the new language. The reason we didn't worry about it last time is because even though it said anyone who attends a nationally recognized program would fall under this, we weren't worried because you had to be a chiropractor or a vet to get into the program, but somebody just wanted it to be more explicit. So this passed on consent here and unanimously in the Senate, consent in the House and unanimously in the Senate. So I think that with these slight changes, nobody will object and it should go through
Thank you.
nicely.
Representative Howard.
Thank you, Madam Chair, and thank you for taking my question. So I'm looking at the governor's veto message and the talking about in talking about his reason why he said that there was a number of concerns brought up by stakeholders. Have those been addressed?
Yeah,
Okay.
I'm not quite sure why he said a number. This was the main problem.
Okay.
It was, as far as I have heard, it was a president of one of the chiropractic associations who's no longer there, but that's the thing they wanted addressed.
All right, thank you.
Thank you.
Representative Long.
I got an email from a veterinarian opposing this who said, I forget the exact details, but said something about there not being any exam or any sort of performance standards that people will be held accountable to. And I'm just wondering, do you know what's involved in completion of an animal chiropractic program, and if that involves some kind of performance examination to ensure people actually have the skills that the program is
Right.
supposed
Thank you
to
for
be
asking, because apparently there was a misunderstanding last year about that very subject, that it was believed somehow that this was going to eliminate licensing, and it does not. The people who go are either veterinarians or already licensed chiropractors. And I don't know the details of these programs, but they are nationally recognized programs and it specifies that it has to be programs accepted by the director of OPLC, and they are currently practicing all over the country, and several states have already addressed this and are moving ahead brilliantly. So it's not just anyone who wants to practice. You have to go to a nationally recognized program, and you would already be a chiropractor or veterinarian anyway, so you would understand the mechanisms and training anyway.
Okay. Other questions? Thank you very much. And Representative, if you put in a pink card, our clerk would appreciate it.
Bill 2. Thank you.
Is there anyone else who wishes to testify on House Bill 267? Please
Good
introduce
afternoon. I'm
yourself.
Kurt Ehrenberg. I'm the New Hampshire State Director for the Humane Society of the United States. And we would like to put in a word in support for the animals and the owners that want to utilize a chiropractor. We believe this bill allows them to do that without any other problems at this point.
Thank you. Are there any questions? Thank you for your
Thank you.
testimony. All right. Representative Howard, sorry.
Yeah, I just wanted to say
Sorry.
for online sign-ins, we have 4 in support, 1 in opposition.
All right, and on the previous bill, it was 6 and 6. For those who are interested, so that's much more controversial. Anyone else wishes to testify? Not seeing any, I'm going to close the hearing on House Bill 267, and we have a couple of minutes before the next one.
Thank you. It is 2 o'clock, so I will open the hearing on House Bill 85 and introduce the prime sponsor, Carol McGuire.
Thank you, Madam Chair, members of the committee. I'm Carol McGuire from representing Merrimack District 27, which is the towns of Allenstown, Dunbarton, Epsom, and Hooksett. And House Bill 85 was a request of the Hospital Association. What it does is it creates a temporary license for student respiratory therapists to be employed by hospitals doing the portions of their profession that they have already learned under the supervision of a full licensure. It's a temporary license because it's only while they are completing their education. And if you want more details, there's a member of the Hospital Association ready to speak on it. I will answer any other questions.
Seeing none, thank you. Kathy Bizarro Thornburg, would you like to present? Thank you.
Good afternoon, Madam Chairman and members of the committee. For the record, my name is Kathy Bizarro Thunberg. I'm the Executive Vice President, New Hampshire Hospital Association, representing all 26 of our state's community hospitals, as well as our specialty hospitals. The Hospital Association supports House Bill 85, and we really appreciate Representative McGuire's prime sponsorship of this bill. The origins of this bill stem directly from Health Force New Hampshire, a statewide collaborative of healthcare professionals, including educators and respiratory therapists who work with our hospitals, and they help to grow, retain, and sustain a skilled healthcare workforce in our state. They reached out to us to share that many other states, including Maine, Vermont, and Massachusetts, allow respiratory therapy students to work under a temporary license. They have seen firsthand that students opt to work in other states, not New Hampshire, because they can easily obtain a temporary license to work while still a student. Respiratory therapists are really hard to recruit. As of October 2024, based on a recent report that we collated, there was a 21.7% vacancy rate for hospital-employed respiratory therapists. If we could encourage students to work while going to school here in New Hampshire, there may be a higher likelihood of them deciding to stay and work in our state once they have graduated. We need to remove barriers to recruiting healthcare professionals such as respiratory therapists, and this bill is a great step in that direction. So the bill does essentially three things. It adds a new section for a student temporary license and defines the limited scope to being a student working in a healthcare setting under supervision who may practice for a limited period of time and may only practice the skills that they have shown competency in. This also requires rulemaking by OPLC. It adds language to distinguish between a student practicing their clinical skills strictly as a student versus working as a temporarily licensed respiratory therapist. And lastly, it requires that the student must show their employer their temporary license. So thank you for the opportunity to provide our comments on this bill and happy to answer any questions.
Representative Sitek.
Could you repeat your second point, please?
The second point was it adds language to distinguish between a student practicing their clinical skill set strictly as a student. So many clinical students usually spend time in hospitals practicing their skill set while they're a student, versus there's also time that they could spend working and getting paid for that work to work under a respiratory therapist during their time, and that would be when they would be temporarily licensed.
Yeah, follow up.
So this would authorize them to work in addition to their student activities.
Practicing their skill set,
Okay.
correct.
The second question, if I may.
Yes.
Would you spell your last name, the Thunberg part?
Sure, it's THUNBERG, and
you.
you should have received a copy of my testimony as well. Thank you.
Thank you. Are there other questions? Representative Grata?
You. So this might be better addressed by OPLC, but in the case, because I see that in rulemaking, they'll be the ones who put together the rules for this. If a student decides that they don't want to be in this class anymore and they leave the school, I would imagine then they would lose their license to They would lose their temporary license, right? Because they have to be enrolled in the class.
I believe that would be the case, and I'm sure OPLC could address exactly how that would be structured. They'd also would lose their supervisory oversight too if they decided to not be working there either.
Thank you.
Thank you.
Thank you. Other questions? Seeing none.
I
thank
have
you.
one.
Oh, sorry, Representative Pearson.
Sorry. And this is, you may not be able to answer this one because you mentioned a 21% vacancy rate. So that it just led me to two thoughts. How long does it take to become a respiratory therapist?
There is
If you
one
know.
school in New Hampshire, I believe it's River Valley, that does it. I believe it's a 2-year program.
Yeah. What does a respiratory therapist make? I mean, what
Off
kind
the
of?
top of my head, I do not know, but I
Okay.
can find out for you.
All right. I was just curious.
Yep.
Thank you.
Thank you very much.
Thank
and
you.
I apologize for that, Representative Pearson. I didn't see your hand. Okay. And I'd like to call Dejarius and Nick Pry from OPLC, please. Sounds like there's a couple questions for you.
Good afternoon. It's nice to see you all again. Just for the record, Deanna Juris, Executive Director, OPLC.
And Nicholas Fry, General Counsel.
Representative Gada, did you have a question?
Yes, thank you. I just wanted to make sure that in the rulemaking, you're going to have a plan for students who decide that they don't want to continue with their education in this field and want to leave school early.
So are you kind of alluding to the 2-year, right? So there's two scenarios that could happen, right? So if someone is leaving licensure, one of the requirements is that they're a student. So once they're no longer a student, they can't have that license. The second component is if they're continuing on being a student, then they could renew that license.
Thank you.
Thank you. Representative Slot. I need to get the pronunciation. Slot.
I'm hoping you can correct my understanding. It sounds as though there's a student license involved in this legislation. Does that sound fair? Can you explain the section of the legislation performed without a license by a student? Is there some segment of the student population who will be exempt from licensure, or am I simply misunderstanding?
Are you referring to, I'm looking on 4 respiratory care practice exemptions from licensure? You talking about that section right there?
I believe it's line 26.
Yes.
Okay.
Yeah. So that's the exemption statute. So there's a carve out for certain students that are doing something for their clinical practice. So that's an exemption. This is to actually allow, the licensure is to allow students to work at hospitals on their own that are farther along in their matriculation.
Thank you.
Thank you. And just to ask another clarifying question for myself. So this is one that will not be required for students who just want to do their coursework, only for those who want to make some money while practicing their skills.
Correct.
Thank you. Yes. Representative Schmidt?
So I apologize. You may have said it and I didn't catch it. Are you taking a position on the bill or just for general intro?
No position. The one thing we would ask though is that if the bill does go through, it would be helpful for us to have the language temporary student license used consistently throughout this proposed bill, or what would become a statute, just from our perspective, because we have temporary licenses that we already deal with, and this would be, it would just be less confusing for us.
Thank you.
So just for your reference, we've identified in the printed bill, line 15, a student who has obtained a temporary license, if the word student could be entered. So consistent with lines 12 and 13. Just the temporary license means something different. So temporary student license would be specific just to this and would just help us operationalize that.
Thank you. That's very helpful. Thank you. And if there's no further questions, thank you very much. Is there anybody else who wanted to speak on this bill? See, oh, sorry. And if you'd like to announce what the online was, Representative Howard.
We had 2 in support online and 0 in opposition.
Thank you. And with that, this ends the public hearing of House Bill 85, and we will reconvene again at 2:30 for House Bill 82. Thank you. We're not starting until 2:30, which is a minute away, but I only have 2 cards in front of me, so I'm not sure if all of you are going to be here just to watch. If you're going to speak, please fill out a pink card and hand it up. Okay. 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 Thank you and welcome back. It is now 2:30 and I will open the hearing on House Bill 82 and I will call the prime sponsor, Representative Carol McGuire.
Thank you, Madam Chair, members of the committee. Carol McGuire, representing Merrimack 27. And House Bill 82 is a request of the OPLC. It is essentially a compilation of the cleanup language that was submitted last year on bills that didn't pass. We had a number of them that we either voted to kill for other reasons or retained in committee and were not passed. But this does not have any policy differences. It is purely cleaning up the statutory conflict between the various licensing boards language and the OPLC language. If you look at the list of professions involved, the last 3, I believe, are not actually addressed except to be added to the list of boards, license commissions, et cetera, that are covered under the OPLC, like the voluntary doula and lactation specialist, the nurse agency registration, and I think the bondsman. I also have an amendment, which I passed out earlier, which adds in some language that I had thought I'd included in this bill, but didn't. This is to clarify under the medical imaging professionals that no matter how many specialties you are qualified for, you only need 1 license. This is what has been done all along. But some lawyer read the statute and said, oh, you ought to have a separate license for each modality, which seems redundant. This amendment 0010H just says you have a license and you've proven your qualifications for every modality, you're licensed for those modalities, just to simplify things. I will try to answer any questions.
Are there any questions from the committee? Representative Grada?
Thank you, Madam. Thank you, Madam Chair. Representative McGuire, when we were addressing the bill, these boards last year, they were sort of set aside from the other boards who underwent this type of change.
Okay. Hold on. There's some confusion as to whether, since you were listed as a co-sponsor, whether you can ask questions or not.
Yes. I will mention that, for example, the podiatrists, there was no objection to their statutory cleanup, but the bill it was addressed in was a bill to combine the Board of Podiatry with the Board of Medicine, and that policy was not accepted until the bill was killed and this part was lost. And similarly for some of the other professions.
I have a question to the chair. Have we changed policy? I thought that if you were a co-sponsor, you had to decide whether you would testify or ask questions, but you simply couldn't do both, but you could do one or the other.
Thank you. That was my understanding as well. I don't know. That might be something that we should ask the clerk to find out that information.
I mean, that's been policy in the past. Unless at a chairs meeting, that's been
No.
stated differently.
normally you, like you say, if you're offering testimony, you don't ask questions, and preferably, even if you are not providing testimony, you don't actively ask questions, but there may be cases where information is needed.
And that has been my understanding in the past as well. I was asked the question by the clerk as to whether that was the appropriate process. And that's one where we can get more information on that.
Okay.
And then I do have an actual
Okay.
question.
Then Representative Pearson for an actual question.
Thank you, Madam Chair. On page 4 in the middle, 19, you're striking out if the office denies the issuance of a license or temporary permit to any applicant, the initial fee deposited shall be retained as an application fee. OPLC has to process these applications, which is work. Why would we not retain that if it is taking up
I
their time?
believe the question of application fees is covered in the OPLC statute and rules rather than in each professional or statute. This one is only about engineers.
Okay, I'm getting the head nod from the boss back
Yes,
there, so.
And they will confirm that.
Thank you. And we now have clarification that if you're a co-sponsor, you can either, for anything, you can either testify or you can participate on the committee side and ask questions. So you cannot do both.
Okay.
Yes. So, I didn't know if there was more of a question that you had, Representative Grata, or if that was the whole question.
I'll try again. Thank you. So the under House Bill 655, one of the things that we did is set up a statute for the OPLC office where all of these requirements that are being repealed by the individual boards were placed underneath that statute. So I just want to make sure, and I believe this is right, that all we're doing is taking the boards that had not been considered in that administration change to make these boards compliant with all the other boards where this previous legislation is passed.
That is the intent, and that's what I tried to do. If I was wrong, we'll fix it.
Thank you. Any other questions? Seeing none, thank you very much, Representative McGuire. Next, I will call up Kathy Bizzaro-Thornburg from the New Hampshire Hospital Association.
Good afternoon. For the record again, Kathy Bizzaro-Thunberg, Executive Vice President, New Hampshire Hospital Association. And I just wanted to speak in support of the amendment 00108 from Representative McGuire, adding the clarification of the licensure process for the Medical Imaging and Radiation Therapy Board. And also, we may be bringing in some additional clarifying language if this does go to subcommittee, just for consistency within the statute. So thank you.
Thank you. Are there any questions? Seeing none, thank you very much.
Thank you.
Next, I'll call up Joe Haas. I couldn't quite realize, of Gilmington. I was trying to see what that was. Thank you very much.
What was that? I didn't hear that.
Oh, I was trying to ask for a clarification, but then I read it when I looked at it again.
Oh,
So
okay,
thank you.
Joe Haas from Gilmanton, and I came in about a minute or two late. All I heard from the prime sponsor was that somehow this is to consolidate rather than to have separate sections, because my email that I sent to her and the co-sponsor this morning was not answered because of the busyness here. And it deals with page 11, lines 24 to 28, dealing with auctioneers. And I know that, you're changing it off from the board to the office of OPLC. I understand that, but number 38, could the sponsor maybe come back and explain to me and you, if she has not done already, of why that you're getting rid of the 311-B:5, Roman numeral 5, relative to qualifications regarding character. Is that possible?
Yes, thank you.
No problem.
Yes, that qualification of good professional character and with no details was primarily used for discrimination. It was used to block unfavored social groups or on a racial or sexual basis, and it is subject to bias and irregular application. It is not something that the office can judge. So when they're doing the application, they can't say good professional character check. What the requirements for the auctioneers do require is personal references from other auctioneers. And it is expected that they will be demonstrating the person's good professional character because of their recommendations. And we don't believe it should be in statute because it cannot be uniformly enforced.
Thank you very much for that clarification.
We do assume good professional character on the part of all licensees.
Thank you, Carol. I've known Carol for years. She's a good state rep from Epsom, I think it is, isn't it?
Yes, representative from Epsom.
Yeah, where I used to go years ago to Barbara and Frank Anderson's Sherwood Inn with the Trojan horse on there, listening in on the Constitution, where I first met David Welch. He told me years ago he used to go there. I didn't know him as a 20-year-old, you know. But anyways, thank you, Carol, again. And then because of the
Excuse me, Mr. Haas, in this room, she's Representative McGuire. Outside, you can call her what you like, but here she's Representative McGuire, okay?
yeah, exactly. You're right. Thank you. But you can call me Joe anytime. Yeah, she said that it's been used for discrimination purposes, but that's only one purpose of that Roman numeral 5. Because if you look back on Roman numeral 2, it does say that other auctioneers can file paperwork to either discredit the person or to appraise them. So it would be nice to maybe redefine that Roman numeral 5 to exclude misuse of that for racial purposes. Because I put into my email that I was at the Board of Auctioneers on a complaint, and I was talking about absolute auctions, and one of the members said, "Oh, yeah, that can occur at any time." I said, no, read the definition. I put it in here, you know, it has to be at the same time, place, cannot be continued to a later date, and even in New York, they have a statute on the books that says the backup bidder, even the bidder or the backup bidder, cannot come forward at a later time to rebid. And that's something that you could look into to perhaps put into New Hampshire statute as an analogy, as a side, similar statute. And I did listen to the presentation this morning, not listen, watch, I should say, and read the captions. My speakers weren't working. But anyways, the new commissioner over there, she said that they don't want to have to, I mean, these people work for a livelihood, and that's fine. And if they screw up, then, discipline them. And if they screw up too much, then oust them and then get another job in another profession. And so I do have a real estate case over there. I could tell you about that. I won't bore you to death with that. But the way I look at it over there, what it is, it's a protection racket because they're protecting their people that pay their
Sir,
fees.
could you just keep to the policy and not make accusations? Sir.
Well, I'm talking about character. The word character is in here. So even while they're being tried to be admitted, they're applying for the license to be an auctioneer, that once they're in, that doesn't stop there. The continuation of character should go above and beyond, because I was at Governor Kelly Ayotte's her first GNC meeting yesterday, and the pastor over there, the father, he said, let's have his truth and justice go further by your activities over here. I always like to say, let the truth go marching on, like in the song of the Civil War. But anyways, that being said, the last thing I want to say too is that your character is in question too, all of you, because I complained to the House Speaker. I said Article 15 of the New Hampshire Constitution says compensation. Compensation is payment for a loss. You have to use your time here, then you get paid. To be paid up front like an attorney retainer is wrong. So you being a judge of other people's character, first your character should be corrected. An error that is not corrected becomes a mistake. So it would be nice for you to look into that and do something about it. Thank you.
Thank you, sir. We'll take a look at this. I think a lot of those things end up in rules as not just in the laws, but we will take a closer eye look. Thank you, sir.
Thank you.
Next, we have Stephen Rancourt. Representing ECBA, so I'd love to know what ECBA is. Thank you.
Good morning, Madam Chair and the committee members. My name is Stephen Rancourt. I'm a licensed electrician in the state of New Hampshire, and I represent the Electrical Contractors Business Association. I'm the executive director, and we just had some small concerns. We represent over 65 actual contractors, about 300 employees. So we had a concern on page 11. The section starts on line 29. The bold wording is on line 36. And I can read it. It's if you start on line 35, it says any person failing to pass his or her first examination by re-examination by an examination entity approved by the board, that's all existing obviously, within 1 year of the first examination and thereafter may be examined as often as desired. The way that we just feel that we're not sure the intent, but the way that it reads, it seems like you can only re-examine one more time in that 1 year period. And that's never been the case. So we're just trying to determine if that's trying to only allow them to re-examine one more time, or if they can still continue to re-examine one more time. And what they're saying is you can only re-examine one more time without filling out a new application. We're not sure if that's what the intent of it was. And if so, it should say that. So they kind of get one re-exam without an additional application, because I believe through their RSAs, they have to act on the application within 90 days. So it just leaves us, I brought this to a couple of board members, and we all have some questions to how it's written and what the intent is. Not necessarily disagree, but would like some clarification to try to fix the wording if possible.
Thank you. That's very helpful insight. This is why it's great to have public testimony. Are there any questions that we have? Thank you very much. We will, this will be going to, once we're done, I'm sure it will be going to the licensing subcommittee, so they will work hard on these details.
Thank you.
Thank you. Next, we have Mark Kondramarki. I'll have you correct me on that because I got a little intimidated. And you are representing the New Hampshire Land Surveyors Association.
Thank you. It's Mark Kondo Demitraki.
Thank you.
Yes. You're familiar with it, I see.
No.
So I represent the New Hampshire Land Surveyors Association. We are the first section of this bill that is being proposed to be effected. And I understand why and the reasoning that the sections that are being repealed are in here. I understand what's happening with the consolidation of information, rulemaking, discipline, etc. through OPLC. I certainly am not necessarily in favor of every aspect of it. but it just seems that we've been here now for, I believe, 3 sessions in dealing with this change, and it seems every single time some part of this transition has been overlooked, and this seems to be no different. There are multiple repeals in here where you're repealing rulemaking of the land surveyors statute. You're repealing the rulemaking for retired status, expiration and renewals, which I understand is all part of administration. That typical day-to-day work that OPLC should be managing and overseeing. But then you're also repealing disciplinary actions, and specifically RSA 310A70 is set to be repealed, which lists certain violations that the board can look at and refer to for disciplinary action, which is the standard boilerplate information, drug use, bad practice, not being a good steward of the license, etc. But in 310A58(6), it specifically says that the board is required to be met by each holder of a license to practice under the subdivision, and how disciplinary actions by the board shall be implemented for violations of these standards. So, according to the statute, the board is still going to maintain some authority for disciplinary actions, yet the list of what the disciplinary actions are is being repealed. So we're back to square one again, which is, I guess we overlooked something, and are we now going to come back in the next session and fix this? Or it creates uncertainty, and it creates instability on what happens now when people are violating these statutes when it comes to practice. And what we are seeing on an association level is a significant increase in people that are now practicing either without a license, shoddy work, maybe they're not following all the rules for time reasons, etc. We know obviously it's very difficult to find a lot of licensed professions. Everybody's busy, it's the economy, etc. Not as many people coming into the workforce, etc. But it just seems that it would be nice if, when this information for repeal and consolidation is proposed, it would be in a more detailed, thoughtful format in such a way as to not create confusion as to what exactly this specifically does. Because, again, you're repealing certain things, but then there's other things that still stand. So now who has the power of what, and who's going to decide what's what? And it would just be very helpful if there was a consistent standard that people could understand, follow, and know, and we wouldn't be in this state of limbo per se, that it's gray, Now who is gonna maintain what, and who has certain authority over what? So I'm certainly in understanding of this, but I think that there's definitely more work that would need to be done, and we as an association are happy to provide our resources to you to help go through this on a very detailed way, so that when it is done, it's done correctly one time without any unintended consequences. And that's our big concern, is that we see the unintended consequences that occur as a result of some of this slipshod, language that we're then coming back. That's housekeeping, right? So, we just want to do this in a very consistent and, thoughtful way. So, thank you.
Thank you. We appreciate you calling attention to that. And I have a similar one. I had 150 feet left out of my boundary line. So it's appreciated to always double check each other's work. So thank you very much. Were there any questions? And thanks. Next, we'll call Dennis McKenney.
Thank you, Madam Chairwoman. My name is Dennis McKenney. I live in Bennington, New Hampshire, in Hillsborough County. I carry both a land surveyor's license and a forester's license. I have some grave concerns about the direction the office is going. My comments today are limited just to the first 12 lines of the bill on page 1 with respect to land surveying. I'm very concerned that the members of the board themselves are being stripped of the authority to, in their opinion, review applications and determine who has met the requirements for licensure. I think that's a step in a fundamentally wrong direction. As Mark stated before me, I'm concerned about the disciplinary procedure. I'd like to think that were there to be a complaint filed against me, that I would be judged by a jury of my peers who have some land surveying experience. And I would ask, what qualifications, knowledge, experience, or judgment do members of the staff at the office have to sit in judgment for those who are licensed in any profession? The purpose of licensure is to protect the public welfare, and I'm not sure that overall, with respect to landowners here, or excuse me, with respect to surveyors and particularly to landowners, that this is taking us in the right direction, particularly since landowning members of the public who engage land surveyors, we are tasked with surveying and defining or recovering what is perhaps in the majority of cases the most valuable asset that they own. So thank you.
Thank you. Any questions? Thank you very much for your testimony. And the only remaining card I have is from the Office of Professional Licensure and Certification. So, Executive Director, thank you.
Good afternoon again. Just for the record, Deanna Juris, Executive Director, OPLC. Just wanted to speak broadly. As noted, this bill was a request of the office, and I just wanted to clarify that the intent behind the drafting and that working with Representative McGuire was just that, to do the cleanup statute. So the policy changes this committee has already recommended, it's been voted on through the whole legislature, signed by the governor, and is current law. So this actually is to avoid confusion because there's conflicting statute, but the 310 changes, the umbrella for the office, are currently controlling. I'm going to leave Attorney Fry to speak to some specific things just from our listening to the other testimony. But just acknowledging that, I will say specific to the electrician's exam, the intent was to, the office has that obligation to process them. And currently the statute reads that an application could be open for 13 years and somebody could come back and take an exam. Operationally, like the office cannot hold those license applications open that long, and there's other statutory implications. So I'll just say, when it goes to subcommittee, we're happy to work with you to make sure that that intent is realized, the wording is correct, and that we can operationalize what we'd like there. So just happy to work with you on that, and I'm sure there'll be some discussion. So we're not married to that language, just want to make sure we're able to comply in other ways. So, and then just for a few more technical pieces, I'll turn it to Attorney Fry. Oh, sorry.
Are you saying that the disciplinary concerns that have been expressed are already covered in existing law?
That Attorney Fry is about to speak to that, so I'm going to turn it over. I'll let him answer that. Yep.
That's all right.
Yeah, so the statute for land surveyors that was being referenced, RSA 310-A:70, it references certain conduct that's considered professional misconduct. If you look at RSA 310-12 and you compare the language of that statute to RSA 310-12, you will see that the language, if not similar, almost nearly mirrors it. So the intention of this, just like Representative McGuire said, was just to clean that up so that we have one statute. And when the public's trying to surf through multiple statutes, they're only having to look at one as opposed to two. Also, just to speak to, I'm just going to echo what Representative McGuire said again, but we do our best to take into consideration the expertise of the boards. The way that's done, as you guys probably heard this morning, is that the board sets the criteria and objective criteria, just as Representative McGuire was referencing, so that you can have any person make that decision. And so that's how we handle that. And we've already spoke to the electrician's piece. I did also want to bring to the committee's attention that I received communication from New Hampshire Insurance Department. Yep. So they had a proposed amendment to basically use generic language to describe certain sections. I think it's sections 15 and sections 26 that deal with insurance statutes, to reference the practice of practice in New Hampshire. So psychologists that practice in New Hampshire and mental health practitioners that practice in New Hampshire, to ensure that we're capturing in those statutes individuals who are licensed under RSA 310, the 31017, the reciprocity statute or endorsement statute. Because currently written, it just refers to the statutory schemes of the board. So they just want to make sure that we're covering everyone for insurance purposes.
Thank you very much. Are there any questions from the committee? Seeing none, that was very helpful to address those questions that we had from everybody. So thank you very much. I'm not seeing any other pink cards, so I don't see anybody else that looks like they're here to speak on this bill. Oh, sorry, Representative Howard.
Just wanted to say online, we have 2 in support and 2 in opposition.
Thank you, Representative Howard. And with that, I will close the hearing on House Bill 82. And this is the end of our work for the day. Just want to let the committee members know the calendar for next week has already gone out today. So you can check that electronically.
One more thing, Madam Chair, for clarification, 82 is going to subcommittee.
Yes, I
Okay,
actually
just-
said that in the midst of the discussion. So yes,
Okay.
best to put that at the end. It'll be
Perfect.
going to the licensing subcommittee, which Representative Pearson is chairing.